This is a motion to confirm support arrearage. This was filed by the Attorney General's office on July 23rd of 2024. The parties are all here on Zoom today. This is a remote proceeding, and I am sitting outside of Galveston County pursuant to the Texas Family Code, section 201.1045, and I find that nobody has filed any objection to proceeding in this manner. Mr. Tate, can you state your full name for the record, please?
Yes, ma'am. Mallory K. Tate.
Thank you. And Ms. Ricard, can you state your full name for the record, please?
Tasha McCrell Ricard.
Okay, thank you, ma'am. And can you both please raise your right hands to be sworn in? Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hands. And counsel for the Attorney General's office, what can you state your name?
Yes, Koya Armstrong.
Okay, thank you. And I guess as a starting place, there's some housekeeping items. I am an associate judge, so you do have the right to a de novo hearing before the referring court regarding decisions I make. Also, please note, nobody should be recording this. There should be no audio, video recording, photographing, broadcasting, taking snapshots, no recordings of any kind regarding this or any other court matter. And that applies to people who are here today on Zoom, the parties, as well as anyone who may be watching on YouTube. And then also please note that even though you're in your homes, this is court and you are in court, so please treat it that way. That includes staying on camera in the courtroom. You can't just run off because you finished testifying. It's real important that you stay here so we know that you're not frozen. If you leave, we're looking at backgrounds and we don't know if you're able to hear or not. It is real important that you hear what everyone says during the hearing. That way you can respond appropriately if you think you need to. And we do generally take testimony in court. So generally one of you will be a witness at a time where you'll be asked questions by the Assistant Attorney General. If you're not that person, unless you have a legal objection, don't interrupt the person answering and don't answer for them. There is a chance you won't agree with what they're saying. And I realize that. That's why you're having a contested hearing, because you don't agree. And so just wait till it's your turn to be asked questions. And then since you're both representing yourselves, you'll also both be given a chance to speak. And then lastly, just know I'm not with the Attorney General's office. So anything you've spoken to them about or given to them is not given to me or told to me because there's ethical rules and they're not allowed to. And so you're likely to be asked questions that you probably discussed just this morning, or maybe other times you've been in court or on the telephone with them. Just know that none of that information gets to me because it's not supposed to. So even though you're thinking, oh, I told her this, she knows the answer, she probably does. But if you can just answer to the best of your abilities, it will help us get through the hearing faster. So you may proceed, Ms. Armstrong. Are there any agreements?
There are non-agreements, Judge, unfortunately.
That's okay. There's only one real issue, so I wasn't expecting much.
Yes, Judge. Yes, ma'am. May the court take judicial notice of the Attorney General's motion to confirm arrears that was filed with the court on or about July 19th, 2024.
Take judicial notice of the pleading. And I'm looking at their decree. It doesn't look like it. Oh, there's the exhibit. Not the best drafted, but okay. I take judicial notice of your pleading.
And Judge, it should have the pay record attached. If I may enter into evidence an updated copy of the pay record, which I've sent to everyone and labeled as States Exhibit 1, an updated version of the pay record that was already attached to our original pleading.
Does anyone have any objection to me admitting States Exhibit 1 into evidence?
I don't.
Oh, thank you, ma'am. Mr. Tate, do you have any objection?
No, Your Honor.
Okay. States Exhibit 1 is admitted and you may continue.
Thank you, Judge. I'd like to call my first witness, Ms. Ricard. Ma'am, are you the mother who, in this case, who was ordered to receive child support?
Yes.
And who were you ordered to receive child support from?
Dr. Mallory K. Tate Sr.
Okay. And did Mr. Tate Sr. pay you the child support and medical support each month as ordered by the court?
No.
Okay. And because he did not, is it fair to say that he has a balance remaining that he owes you for both child support and medical support at this time?
Absolutely.
Okay. Now, State's Exhibit 1 has already been entered into evidence by the court, and you received an updated copy of that this morning. Is that correct?
Correct.
Okay. Judge, may I share my screen with that exhibit at this time?
You may do so.
Thank you. All right. All right. Okay, Miss Ricard Tate, can you see my screen with the pay record
I
on there?
can.
Okay. Now, as you can see, says page 1. Can you confirm that this has you and Mr. Tate's name at the top?
Yes, that's correct.
Okay. Now, this is the State's Exhibit 1 already into evidence, but I'm gonna scroll down to the last page of this exhibit. Okay, so give me a moment to scroll down.
16. Mhm.
Okay. Now, as you can see, do you see the left column that says April 30th, 2025?
Yes, ma'am.
Okay. Can you see the child support column here?
Yes.
Okay. Can you confirm that as of April 30th, 2025, Mr. Tate was in the arrears $95,713.34 for child support as of that date?
Yes, that's correct.
And are you joining me in asking the court to take a child support judgment against Mr. Tate for that date and that amount?
Yes, ma'am.
And are you asking the court to set a fair payout starting June 1st, 2024 towards that amount, to pay
Correct.
towards that amount?
Correct. Because he's been paying monthly, like I mentioned earlier.
Right. Okay. So, and what amount are you okay with him paying starting June 1st towards the child support arrears?
Really,
That
the
would be
max,
fair.
I mean, if the payment can stay the same, that's fine.
Okay. So is it $1,500 a month that you're wanting to go towards the child support arrears starting June
Yes.
1st, 2025?
Yes, ma'am.
All right. Now let's look over to the column entitled medical support. Do you see that on the exhibit, Ms. Ricard?
Yes, ma'am.
Okay. And if we go all the way down and go across to April 30, from April 30, do you see that he has a medical support balance as well?
Yes, ma'am.
Okay. And according to State's Exhibit 1, do you agree with me that he has a medical support as of April 30th, 2025 in the amount of $17,956.96?
I agree.
And are you joining me in asking the court to take a medical support judgment against Mr. Tate for that amount and that date?
Yes, ma'am.
Okay. And are you okay with are you asking the court to have him pay, I think it was $125 per month?
Yes, ma'am.
And that payment would also begin June 1st, 2025. Is that correct?
Correct.
And then you are aware that any interest that may accrue, that will be, he will be responsible for any of that as well.
Yes, ma'am.
Now the kids, the twins, they've already emancipated. Is that right?
Correct.
Okay. And so the only thing remaining are these two balances. Is that right?
Correct.
Okay.
Correct.
All right. If I may stop sharing my screen at this time, Judge?
You may do so.
Okay. All right, Mr. Ricard. Now we've talked about the child support arrears and a recommended payout. Now you understand the judge decides the payout, but you've given your recommendation as well as for medical arrears and recommendation for payout. And that is what you're asking for. Is that right?
Correct.
Okay. Now, court costs, if billed by Galveston County, you understand and agree that they would be billed to Mr. Tate due a year from today. Is that correct?
Correct.
Okay. And you believe this order, if the judge agrees to these payouts in an order, that would be in the best interest of your children?
Absolutely. Yes, ma'am. Correct.
I pass this witness, Judge, at this time.
Okay. You may call your next witness.
Your Honor.
I will call Mr. Tate.
Okay. Good morning, Your Honor.
Morning.
Mr. Tate, I haven't asked any questions yet.
Okay.
Mr. Tate, did you also see a copy of the pay record that I emailed to you this morning, an updated copy of it?
Yes,
Actually.
ma'am.
Okay. And did you see the child support arrears that were listed on the pay record?
Yes, ma'am. And I've stated I would not like to talk to you.
Objection, non-responsive after yes,
Sir,
ma'am.
It said at the beginning of the hearing, we take testimony where she asks you questions. You can't come to court and
Excellent.
refuse to answer questions as per testimony. So if you can just please answer the questions, and then you will be given a chance to speak as well. But she knows what I'm generally looking for to get the testimony out, and then you'll get a chance to speak as well. So if you can please answer the legal questions being asked, I'd appreciate it. The factual questions being asked.
Okay. Now,
Yep.
Mr. Tate, we are here, this is the third setting on this motion to confirm arrears. Were you aware of that?
No, I was not aware.
It's okay. Did you also see them? It's okay if you weren't, that's okay. Did you also see the medical support arrears that were listed on the pay record?
Yes, ma'am.
Okay, now let's go back to the child support arrears, $95,713.34. How much per month do you think you can afford, are you currently paying right now?
It's taken out my check, $1,600.
Would it be 1625?
$16.27.76.
Okay, thank you, sir.
Wait, what number was
And
that? 16,
$16.27.76.
I'm sorry, 1627.67?
16.27 and 76 cents.
76. Okay, so that's what you're offering to pay?
Yeah.
Okay, that's very precise.
okay, thank you. Yes, it is. Thank you, Mr. Tate. Now you heard Ms. Ricard's testimony that she was requesting the judge to set at least a minimum of $1,500 towards her child support arrears plus $125 for the medical arrears, which would be right in line, almost $2 shy, $2.76 to be exact, shy of what you're already paying. So you're okay with that payout?
No, ma'am.
Okay. So what amount would you like to pay towards your child support arrears then?
I paid enough. I mean, I paid enough. I asked for an attorney, and what I'm stating is that the arrears are based off a forged document.
Objection, non-responsive to my question.
I think his answer was zero. He wants to pay zero.
Yeah.
Oh, he did say zero.
So,
Yes.
if you can just listen to the question and answer the question.
Okay. My next question, thank you, Judge. My next question is, how much do you want to pay towards the medical support arrears?
Zero.
Okay. I pass this witness. Judge, I have no further questions.
Okay. So as I said, both of you are going to get a chance to tell me your sides. The state doesn't represent either of you. I'm going to start with Mr. Tate. Is there anything additional you think I need to hear?
No. Okay. Good morning, Your Honor. I'm a non-custodial parent. I respectfully request a temporary pause or enforcement actions, including child support arrears and passport restrictions, until I can fully be recognized by legal counsel. I recently discovered significant issues regarding documentation that I did not authorize or sign, and I have begun to gather a lot of information about it to address these concerns. At this time, I'm not prepared to proceed without an attorney, and I respectfully ask that the court grant a brief continuance that my legal counsel representation can help me gather more information. If you need more information, I can tell you.
I do, sir, because this case has been on file since July. The last setting I see was reset back in February, so that's 3 months ago, to today, and it was specifically reset, it looks like, for trial on the merits and to allow time for your attorney to appear.
Right.
So it's now 3 months later, and you're asking the same thing. The case has been on file for basically a whole year, and so I am concerned.
Okay.
So I'm going to need, if you want me to be doing something for you, vagueness is not,
Okay.
it's not useful for me.
Okay.
This is court.
Okay.
I can't do favors to either of you or the AG's office. If someone wants something from me, they have to truly explain it.
Yes, ma'am. So I got serious
All
concerns.
parties in the case.
I got serious concerns about forged documents, as far as a divorce decree and citation of waiver that I did not sign. I was not in the country at the time, and the signature was forged. We were waiting for documentation from immigrations to forward to the court that I was not in the United States at the time of the signature.
Objection, non-specificity. If he could specify which document he was referring to. Judge.
I stated the divorce decree.
The waiver of citation.
Wait.
It's the waiver of citation he's talking about
Oh.
for the divorce decree. It's
Yeah.
the first document in Odyssey.
Yes, I was not in the country October 12th. October 2012. Nor the second signature. I was not in the country. So I have documentation
I'm sorry.
that we're pulling up that I was not in the country. Never was in front of Lolita Holiday, never signed those documents. Also, due process was not given when my taxes were taken, nor when my passport was taken.
Objection, Your Honor, he's misstating the law.
I never received documentation when my passport was taken, nor
What does your passport have to do with? I don't even understand what that has to do. What do you mean your passport taken by who?
The Attorney General and child support. That's
Oh,
part of
you're
my
talking
work.
about, okay, this is a separate issue entirely. You're talking about some of the automated remedies they use.
Yes.
Okay, that is
I
not
have the
for me today. I thought
relevance.
I thought passport was related to him being out of the country for this citation. So I didn't understand that it was a totally different issue. Okay, which is why I was confused too, because I'm like, what does the passport have to do with signing a waiver? It could have been your ID, but is he claiming someone absconded with the passport? I was confused. Okay, yeah, that is an administrative remedy they do. And that is something you'll have to deal with and address through them. It's not before me. And so right now, all that's before me is the motion to confirm arrears.
Well,
If I may
And I'm
respond,
just concerned that it's taking this long to get this documentation, sir. Because as I said, I know you've known about this since at least February, if not before. Can you explain why it's taking more than 3 months to get the proof you claim you have?
Your Honor,
why your attorney's not here today when you,
Your Honor, I sent the information into the child support office and they ignored it. So therefore, I'm retained an attorney after the fact. I sent this in several times, documented that I was not in the country. So therefore, I had to go to immigration and hire several lawyers because it seems like I'm fighting the Attorney General office in Lamarck or something. Because this was adjusted several times. I got modifications to this because the salary that is based on is not, I never made that salary.
objection relevance as to a modification. We are not set on a modification.
No, he's claiming it was. So, sir, you're claiming it was modified. I think it's relevant. I just don't. I'm looking at the court file. I'm going to overrule the objection about relevance, but sorry, I am questioning. I don't want to waste my time or their time. I don't see any modifications in the court file here in Galveston County. Are you claiming this was modified somewhere else and that some order exists that is not on the AG system or the Galveston County District Clerk's system?
It was modified in Galveston County in Lamarck. She did not show up several times and they adjusted it and it was modified.
Okay. So again, this might help you, but you probably should have gotten a lawyer after the last time, like you said you were going to. There's the Attorney General's office, and they do a lot of administrative things. Some things go through court and some things don't. They cannot modify child support without it going through the court. And so if you went to their office and discussed modifying, unless it went through the court system, it didn't modify it. And so I'm thinking you might have gone to the office numerous times. But I do not see in the court file that it became a court order. So just so you're aware of that, it has not been modified.
Okay. Well, on behalf of what I stated, went to the Lamarck office, is modified. Therefore, they stated that they would turn this.
Objection hearsay of what was stated.
Sir, the modification, unless you're claiming that there's an order signed by a judge you have that's not in the district clerk's records, that is not, we need another issue. I can't go back in time to modify the order. Sorry, it's either been modified or it hasn't. It's kind of a check the box, yes or no. And as far as I can see, it's a no.
Okay, it was modified in the support given to me, and the statement, the letter sent to my house stated that it was modified. I wasn't a part of it saying going to court. They modified it, sent the letter to me. She did not show up.
Objection,
so I'm not resetting
hearsay.
your case because you think it was modified. Okay, so let's go back to the other issue, which I have concerns about. You claiming that the waiver was fraudulent or whatever you're claiming it is, that concerns me. The order modified is not a reason for me to reschedule this case. We're not going back in time to figure out what happened on failed CSRPs. We
Okay.
can't do that.
Judge, if I may respond to his claim.
You may.
He claims that, so in court, Judge, Your Honor, we were here October 21st, 2024. Okay, both parties were present. The case was, both parties were present. We did a reset, and it was reset for another court date. Okay. Mr. Tate was then emailed copies of the motion to, of our petition to confirm arrears, and he was present in court. And then he was given opportunity to reset, to hire an attorney, and then the case got reset. And then he wanted another reset to hire an attorney, and then here we are again. So we were able to close his service path on October 21st, 2024, because he was present. He accepted service on the record. He was emailed a copy of that petition the very same day.
You were emailed a package stating the facts that I stated, as you said my attorney was supposed to send it. So I said, okay.
Why
Your
is
Honor,
your attorney
I have to
not here today,
object.
sir? Sir, why is your attorney not here today?
Because it was a mistake with my attorney. Sorry.
Can you call him and get him here today?
She's not available right now till 2 o'clock.
What is your attorney's name?
Christine Thrash.
I'm sorry, you came in and out.
Attorney Thrash. Attorney
You're still
Thrash.
coming in and out, sir.
Attorney Christine Thrash.
Christine Thrash. Okay.
Your Honor, he does not have an attorney. If you look on the Galveston District Clerk website, no attorney has filed a notice of appearance with the court. No attorney has filed a notice of appearance or emailed it to our office. So as we sit here today, Judge, he is not represented. He is attempting to reset the case again, which this court so graciously allowed in February. He's asking for the same thing again. And I'm objecting to the reset. We're already in the middle of a hearing, and I would just like to conclude the hearing and get a final order, because this case has been almost a year at this point, and he has no pleadings on file.
Attorneys, I have a right to legal counsel. So you keep trying to bully me on this, and this is my right. Okay. So,
well, sir, we gave you the chance to get an attorney, and by we, I don't just mean the AG's up. The court, when we were set in February, 3 months was given to you to hire a lawyer. And so while it is your right to have a lawyer, it's not your right to indefinitely postpone the case to get that lawyer. And that's where my concern is coming from. This case, I want to fairness, and I am concerned if you had that fraudulently done, but why your attorney, who's a good attorney, wouldn't have filed something on your behalf or something to let the AG's office know that they're there is a little confusing. These allegations are big. Why you wouldn't have, let me just say, to overturn, even if you prove to me today that this is fraudulent, it still does not overturn your divorce decree. It's an extreme remedy that you're asking for, because your divorce decree is from 2013, so over 10 years old.
yeah,
So knowing,
Oh no, you signed the citation when you were home to visit. Yes, you did. So don't even play games, Mallory.
No.
I don't have time for your games.
ma'am, please don't speak to him, and please don't speak that rude. I do want to hear your side. It would be very helpful, but speaking to him and being rude does not help the hearing. It makes things escalate. So please don't do that.
My apologies.
Okay, but if you'd like to respond with something you know that would be helpful, I would appreciate it. Is there anything you'd like to say, Ms. Ricard, in regard to this issue?
Yes, when he was home in 2012, he signed that citation in front of several people, and he knows this. And I don't know why he's saying he's not aware of his divorce decree. Before it was filed with the court, I have several emails where he was in agreement of it. So these games that Mallory Tate is trying to play, they have, like you said, this has been going on from 2012, and here we are in 2025. The only reason he's disputing these rears is because he was unable to obtain his passport. If you look at the payment of the record, it'll show he didn't make consistent payments until he actually received a job on the table, because he was getting paid cash and his money could not be traced. He hasn't filed income tax. I mean, it's just it's various layers to this. And I don't know why he's refuting that he doesn't owe. Like I said, he didn't start paying consistently for the rears until 2021, after the kids graduated from high school. Like I said, so I mean, I have evidence I'm not about to go back and forth with the court today about a divorce decree, because that's not what we're here for. We're here for the arrears. You did not support your kids. When you were ordered to pay child support, you had time to do modifications. When you had the opportunity, you claimed you did them. If you did them, the court would have copies of them. If it's not documented, it didn't happen.
Judge, and may I add to that? Furthermore, we are not here to get he's out of time for de novo, motion for a new trial. This was in 2013. The divorce decree was signed by the court at the time. We are here on a confirmation of arrears. There are no pleadings on file. We just need to get a confirmation of arrears done, a payout to get these high arrears paid off. He has no pleadings on file, no evidence of anything presented to the court in writing or anything to the Attorney General's office. He does not have an attorney representing him. He's been given several opportunities to do that, and we just ask the court to confirm the arrears and set a fair payout to begin June 1, 2025. Thank you, Your Honor.
Your Honor,
You may briefly speak, sir.
Your Honor, the salary that was on the divorce decree is impossible. I never made that when I came back to the United States.
Objection relevance as to what child support was ordered back in 2012. We are here for a confirmation of arrears, Your Honor, not a de novo, not a motion for new trial to overturn that divorce decree from 2013 in any way. So I have to object relevance.
Sir, she has to interrupt. Remember I said don't interrupt unless you have a legal objection. That was a legal objection.
He's interrupting me. I was stating a fact.
Sir, she made a legal objection. Sir, I'm going to sustain, sir, please listen to me. Remember I said in the beginning, no interruptions unless it's a legal objection. That was a legal objection, and I'm sustaining her legal objection. I can't go back in time to redo child support that ended a few years ago. And so I'm sustaining her legal objection. Is there anything additional you'd like to say about a different issue?
Yeah, that's why I asked for legal representation. She's on a legal objection. I'm not a lawyer. So she's objecting to what I'm trying to make a statement stating that I did not make the salary that was.
Objection relevance again.
Sustained. Okay. I'm going to find that I'm not resetting this case. I am going to confirm arrears. I'm finding that
and
Mr. Tate has had since October to hire counsel. And he's also had since October, really since before then, to file any possible legal pleading, such as a bill of review regarding this case, and has not. I'm also finding, based on the pay record admitted, that he has made payments on this child support and knew about it in 2013, payments in 2014, payments were made in 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, and 2024, and now 2025. So I believe he's been aware of this obligation for quite some time, and the time frame to file a bill of review has generally passed. That being said, even if he didn't realize it until this action was filed, he's had time to file it since then as well, and it has not been done. So I am confirming the child support arrears and rendering judgment. I am ordering a child support judgment against Mr. Tate in the amount of $95,713.34 as of April 30th, 2025. And I'm ordering that he pay that judgment back at a rate of $1,500 per month. Sir, can you please come back? I am also ordering a medical support judgment of $125 per month. The medical support judgment is $17,956.96 as of April 30th, 2025. I'm ordering that Mr. Tate pay that back at a rate of $125 per month as of June 1st, 2025. The payments all begin June 1st, 2025. And I'm ordering that he pay court costs to Galveston County on or before May 5th of 2026. Mr. Tate, can you please turn on your camera so I know you're still there? I'm going to remind you, I've said this at the beginning, and it's also in my waiting room, my virtual waiting room. You do have a right to a de novo hearing before the referring court regarding any matters. If you wish to do that, I recommend you speak to Ms. Thrash as soon as possible, and she can file any necessary paperwork. But that is my ruling today, and the state is going to draft an order based on my ruling and they'll be sending it to you through DocuSign to review and sign off on. If you don't sign off on it, they will be just submitting it to me based on my ruling, and I'll review and make sure it matches the ruling, and then I will sign off on it. And so
Thank you.
we'll have you all go back to the breakout rooms where you'll get a chance to review the order. But thank you both for coming in.
Thank you. I'll get it drafted and I'll meet you in your rooms to help you sign it. Thank you.
Rashad
I'll be
Cockerham
there.
and Kara Delane Woodworth. Both were already sworn in this morning and remain under oath to tell the truth. Counsel remains Sharon Hernandez for the Attorney General's office. And Ms. Hernandez, what are you reapproaching about?
Just to have Mr. Cochran on the record, he stated he received everything we sent him. He just didn't want to open all the DocuSigns because it was too many. So I just wanted clear that we confirmed his information.
I'm sorry, he can't hear. He's not connected to audio. Sir, you need to connect to audio. Does he still have the other device in the room, or did he hang up?
No, but he was okay. He was speaking with you, Elisa, in the other room.
Give me 1 second. I'm moving his other device.
Oh, okay. He's still on two devices. Understand.
To check.
Okay.
And now we've lost both of them.
Okay, I can hear you now.
Okay, let me begin everything again. We are back on the record, and people were sworn in earlier today, and they remain under oath to tell the truth. Sharon Hernandez is still here for the Office of the Attorney General. Ms. Hernandez, what are you reapproaching about?
We would like I'd like to call Mr. Cockersham to testify to his recent admission that he received appointment letters and everything from the Attorney General on DocuSign. He just chose not to open up those documents because he said it was too many things coming in. May I call him to testify?
You may.
Mr. Cockersham, did you get DocuSign letters from the Attorney General's office?
Yes,
And did you open some of them or all of them or none of them?
none of them because I was unaware that it was paternity related. I just thought it was regular, like, documents I received in the mail.
And when
What time
Miss-
frame are we talking?
did you get these in January, February, March?
I started receiving them like at the end of February and March.
Okay, and why did
But
you
no
wait?
one-
Why did you
Because
wait till? Okay, hold on. Why did you wait until last week or a few weeks ago to contact the Attorney General to ask what they were?
because no one had told me over the phone what they were, ma'am. I have not talked to anyone from the Attorney General's office since January. So nobody told me I would be receiving DocuSigns or I would have to sign anything or I would have signed it. Like nobody told me that's what I would be receiving. I haven't talked to anyone on
Okay.
the phone.
Did you receive a voicemail message from the Attorney General March 11, 2025?
No, I don't recall any messages.
I'm going to stop this as moot. Had all this been presented to me at the last setting, sir, you would have been defaulted. But the AG's office only knew that they sent letters at the last setting. I don't know why. Regardless, you're here today and you know about it now. Is that correct?
Yes, ma'am.
Okay, and you know that I'm guessing it's scheduled now for your initial swabbing?
Yes, ma'am.
Okay, and you know to check if you receive DocuSigns, you now know that you should open them, right? In case something
Yes.
happens. Okay, and
Yes.
you know that if you get letters from them, you should open that.
Yes.
Okay, I just want you to be aware, if at the next setting they come back and you're not here, but they can prove to me they've sent you DocuSign and they've sent you letters and you still don't go in and get swabbed, you can be defaulted.
Okay.
Just want you to understand that.
What-
Okay.
what-
I'd
what
rather
is-
you, now between you and me, I'd rather you go get swabbed and then we'll have the DNA results and then we'll know what to do going forward from there. But at this point, this has dragged on a while. And so I just want to make sure all the ducks are in a row now so you can get swabbed and we can come back with some results. Do you have any questions for anybody about the swabbing process and how they're going to communicate with you?
No, she told me that she will be sending me some documents by the end of the day or tomorrow, but
Okay.
that's it.
Okay, and do you know how she's going to send them to you?
I'm assuming DocuSign.
Okay, and you're going to open them this time. All right.
Yes.
Okay, and just so you know, sometimes DocuSigns are for signatures. They also use it sometimes just to send the information. It's just quicker than sending it by any other means. So just be aware they don't always use email. They sometimes use DocuSign to send documents to you that don't necessarily need signatures. And you might too get something, Ms. Woodworth, I don't know. So just be aware if any of you get DocuSigns from the AG's office, please open them.
Thank
Okay.
you.
Okay.
Thank you.
And what reset date did you all choose?
Oh, okay, 1 second. Let's see. He's going May 17th for his appointment.
Okay.
So, how about I think June 18th, Your Honor? A month should be enough time. Yeah, June 18th at 8:30 on Zoom.
Okay. And I was going to say, sir, you know where to go for that test, the swabbing? Or is that what they're sending
No,
you?
she hasn't sent me the location yet.
Okay. And that's Ms. Hernandez, you're all going to be sending him that location
Right,
information.
I'm not gonna let him leave till we have it in his hand because
Okay.
I want to be a witness. So if you could go put him back in his room, Miss Campos, and we'll make sure I'm gonna talk to Miss Campos how to do it. So I'll be involved. Thank you.
Okay. Sounds good. Thank you so much. Thank you all. And good luck, everyone. Hopefully when I see you in June, we'll have test results.
Thank you. Okay.
For the record,
Halcyonia Young Fleeton.
this is a contested matter, I'm assuming. What's your time,
Yes,
Ms. Hernandez?
Yes, we do have some agreements.
Okay.
Okay, may I?
No, you may not. Housekeeping items. I am an associate judge, so you all do have the right to a de novo hearing before the referring court. In your house or a car, you are in court, so please treat it like you are in court. Please use civil tones. Please remember to stay on camera. In court, you can't just run off or out of the room, and so you just answer to the best of your abilities.
To Johnson.
They agree about DNA?
Yes, they're both admitting to paternity.
Okay.
The parties have an admission to paternity, Your Honor. I'm sorry. Yes, there's admission to paternity and the child's surname to be changed to Johnson. The child was born on 20. The parties agreed to joint managing conservatorship with standard possession and access order. The parties agreed to a geographic restriction of Galveston County and contiguous counties for the child to reside with her mom. Father, Mr. Rayson Johnson, provides medical and dental insurance at a cost totaling $125. Pardon me?
Slow down a little bit. I'm trying to keep up.
Oh,
with
I'm
you.
sorry.
It's a little bit hard. Okay, and you're about to get
Okay.
some numbers where it gets really hard.
Okay.
What is the number of medical and dental?
He pays, it's $125 monthly, which includes both the medical and the dental for the child.
Okay.
The parties agreed to use AppClose, and the parties agreed to no non-disclosure on this case. There's no family violence. Miss Parker, is this your agreement so far?
Yes, ma'am.
And did you make this agreement freely without any coercion?
That's correct.
And Mr. Johnson, is this your agreement so far?
No, ma'am. It's been violence in the past.
So hold on 1 second. So you want a non-disclosure of your private information from the order?
What does that mean, non-disclosure?
Where we keep your address, email, phone number out of the order? I can come back to that issues. Let me, if you're,
But given that there might have been violent, and does he agree to? Is there anything you do? Do you agree to all of that other stuff? Because a lot of that is actually just as important if there's been violence. So I guess I'm not sure what he does and doesn't agree to. You might have to go through it one by one.
Okay,
I'm not sure he even understands what he's agreeing to based on that question.
Sure, Your Honor. So, Mr. Johnson, are you agreeing to paternity of you as the father?
Yes, ma'am.
And are you agreeing to be joint managing conservator with Ms. Parker, where y'all make decisions regarding education, health, her, basic upbringing together?
Yes, ma'am.
And are you agreeing to the standard possession and access order, which basically says you have visitation or possession and access with Ari on first, third, fifth weekend, rotating Christmas break, rotating Thanksgiving, and you have an extended time in the summer, and y'all can do anything else you want, but if that's the standard visitation order, are you agreeing to that?
Yes, ma'am.
Are you agreeing that Miss Parker and Ari can live in Galveston or any county that touches Galveston County?
Yes, ma'am.
All right. Do you agree to continue to carry medical and dental insurance for Ari, which costs you $125 a month?
That's $125 each check that I pay.
So how often do you get paid a month?
Twice.
So is the $250 a month only for the child, or is that for you and the child?
That'll just be for her. That is medical, dental, and vision.
Okay, and that's just for the child, correct?
Yes, ma'am.
Okay, so are you agreeing to pay that $250 a month?
Yes, ma'am.
Okay. Are you agreeing to
Is
use,
it every 2 weeks or is it every,
are you paid on the every 2 weeks or the 1st and the 15th?
I get paid every 2 weeks.
so it varies from month to month, the day?
Yes, ma'am.
Okay, so we'll have to look at that. Okay.
And sir, are you able to break down what you pay towards medical, dental, and vision to give separate amounts to carve the vision out?
No, ma'am, not at this time.
Okay.
Okay, and are you agreeing to use AppClose, which is a free app that the two of you would download to exchange information about the child and put like school schedules, medical documents, things like that? So it would be the primary way y'all communicate about the child?
Yes, ma'am.
All right, and so in the past 2 years, has there been any family violence by Miss Parker to you?
No,
Sir, what was
ma'am,
that
because
noise?
I'm sorry. I didn't mean to interrupt you.
No, what was that noise? I just want to make sure it doesn't happen again. It's very distracting.
It sounded like a truck horn nearby or something. I don't know what that was.
Okay.
So I'm sorry, Mr. Johnson, in the last 2 years, was there family violence or violence by Miss Parker towards you?
She hasn't had access to me. No, ma'am.
Okay, now the child is 4 years old, so has Miss Parker, since the child was born, she's 4 years old, has Miss Parker been violent towards you, physically violent or aggressive in any way?
By showing up at my house and stuff like that, or just putting her hands on me.
Either one, whatever you want to tell the court.
She has been showing. So in the beginning, when
What
she
does
was trying
beginning
to.
mean, sir? The beginning of time? The
No,
beginning
ma'am.
of today?
No.
The beginning of what?
When Ari was 2, I believe, she started showing up at my house and just demanded to talk to me.
What time did this occur? Was it at nighttime, midday? Do you recall what time?
Midday and morning, never at night.
And did you have to call the police or did she leave when you asked her to leave?
I never called the police, but I mean, I avoided her, so I didn't know, what she
Okay.
did after I avoided her, to be honest with you.
Okay. And did you ever open the door or you just talked to her through the door?
I opened the door.
Okay. And then when you opened the door, was there any hands on? Did she put her hands on you or throw anything at you?
No, ma'am.
And how many times did this occur?
To 3 to 4 times.
All right. And other than that, did she ever try to call you and threaten you or harass you on the cell phone?
Several times, but I mean, it was just trying to contact me over the situation because it's a complicated situation.
Okay, sir, I'm just going to stop you all right now. Ms. Parker, you should listen to this too. The point of this hearing is to do an order to establish the parent-child relationship. We're not solving all problems. So the only issues I'm dealing with are establishing the paternity, conservatorship, so it goes to making big decisions, whether you can do that or not together, where, who gets to decide where the child will live and within what jurisdiction, within what area, visitation, child support, and back child support. So I guess, do any of the concerns you're raising, sir, affect any of the issues I just discussed?
The back child support.
It affects the back child support. Okay.
Yes, ma'am.
Do you have any concerns about pickup and drop off of the child? Like if she went to pick up at your house or you went to her house, do you have concerns with the two of you interacting?
No, ma'am.
Okay. So you're not concerned about knowing each other's addresses and being able to pick up and drop off from each other's houses?
We already know each other's addresses and everything, to be honest with you, ma'am. So I haven't had any problem like that.
Okay.
No, ma'am.
Do you have concerns with her knowing your phone number or where you work?
No, ma'am.
Okay. Okay, so these issues, and I'm not sure what to call them, I don't want to mischaracterize them. Her showing up at your house, I guess unannounced, and her calling possibly more than you'd like, those affect the back child support only?
Yes, ma'am.
Okay, but nothing else?
No, ma'am.
Okay. So you agree that nobody needs to have their, like the statutes say there's a presumption that your like address, phone number, where you work, that kind of information will be in the court order. You have no concerns with that for either of you. You're comfortable with following the statute. There's no reason to deviate from it.
No, yes, ma'am.
Okay. So you do agree to everything Ms. Hernandez put on the record initially. Your concerns, I guess, are back child support, I think current child support.
Yes, ma'am.
Is there any other disputed issue, Ms. Hernandez?
No, it's just current and retro child support, Your Honor.
Okay. Okay, you may proceed.
Thank you. At this time, may I call Miss Young Fleeton to testify?
You may.
Okay. Miss Fleeton, did you get a chance? I'm sorry. Where do you work? What is your full name and where do you work?
Sonia Young Fleeton, and I work at the Office of the Attorney General.
All right. Now, did you have a chance to review, how long have you worked there? I apologize.
18 years.
And what is your job title and duties?
I'm a child support officer 5, and I calculate child support, medical support, and dental support, and retroactive child support, medical support, and dental support.
All right. And did you have a chance to review wages for Mr. Johnson regarding this case?
Yes.
And you heard him testify to, I guess, a corrected amount of child support, of medical and dental support paid monthly. Is that correct?
Yes, ma'am.
Now, based on that testimony, what is your conclusion regarding what current child support may be per month?
Okay. The gross is $32.12. Health insurance, $250. The net, $2,572. The child support would be $500 a month.
All right. Now,
and there are no other children.
Okay. Now, did you get a chance to review this case for possible retroactive support?
Yes, I did.
Now, there's a document titled States Exhibit B. Can you identify this document?
Oh, mine doesn't have a number on it. Is it CP or NCP?
NCP.
NCP. Excuse me 1 second. Okay. This is a calculation for retro child support judgment.
Right. And did you generate this in the usual course of business?
Yes.
Your Honor, and Your Honor, may we admit State's Exhibit B in as evidence?
Does anyone have any objection to me admitting State's Exhibit B? Ms. Parker, do you have any objection?
No, ma'am.
Mr. Johnson, do you have any objection?
No, ma'am.
Okay, I'll admit State's Exhibit B is admitted.
Okay, State's Exhibit B, I'm sorry, hold on. I'm sorry. May I? State's Exhibit B, Johnson. Okay, so based on this document, State's Exhibit B, what is your testimony in conclusion regarding this retroactive child support calculation?
So this is the retro that Mr. Johnson is requesting. Starting in from 2023, gross $2,153, net $1,884.35 at 17.5%, at $330 a month for 8 months for a total of $2,640. For 2024, gross $4,368, net $3,660.55 at 17.5%, for a monthly amount of $641 for 12 months for a total of $7,692. For 2025, gross $3,212, net $2,750.72 at 17.5%, for $481 for 3 months for a total of $1,443. For 2025, gross $3,212, net $2,750.72 at 20% at $550 a month at 2 months for $1,100. And the subtotal would be $12,875. Mr. Johnson is requesting a total credit of $2,500, which leaves a final total of $10,375.
All right, thank you. Now, there's another document, State's Exhibit C. Did you create State's Exhibit C in the usual course of your business?
Yes, I did.
And was this exchanged with both parties?
Yes, it was.
Your Honor, may we admit State's Exhibit C in as evidence?
Okay, Ms. Parker, do you have any objection to me admitting State's Exhibit C?
No, ma'am.
Okay, Mr. Johnson, do you have any objection to me admitting State's Exhibit C?
No, ma'am.
Okay, State's Exhibit C is admitted.
Thank you. Ms. Fleeton, what is your conclusion and testimony regarding this document calculating retroactive child support?
Okay, this document is Ms. Parker's request for a retro beginning in 2021. It's at minimum wage at $12.56.67, $11.39.46 net at 17.5% for $199 a month for 12 months for a total of $2,393. For 2022, also at minimum wage, $12.56.67 gross, $11.42.79 net at 17.5% at $200 a month for 12 months for a total of $2,400. For 2023, $21.53 gross, $18.84.35 net at 17.5% at $330 a month for 12 months for a total of $3,960. For 2024, gross $4,368, net $3,660.55 at 17.5% at $641 a month for 12 months for a total of $7,692. For 2025, gross $3,212, net $2,750.72 at 17.5% at $481 a month for 3 months, $1,443. 2025, $3,212 gross, $2,750.72 net at 20% for $550 for 2 months for a total of $1,100. The subtotal would be $18,988 for a credit of $1,000 for a final total of $17,988.
Thank you. Pass the witness, Your Honor.
Okay, Ms. Parker, do you have any questions for Ms. Young-Fleeton?
No, ma'am.
And Mr. Johnson, do you have any questions for Ms. Young-Fleeton?
No, ma'am.
Thank you. And thank you, Ms. Young-Fleeton, for testifying. You may call your next witness.
Thank you. I'll call Mr. Johnson. Mr. Johnson, are you in agreement or disagreement that current child support should be set at $500 a month?
I'm sorry, was it 500 or 525?
It's 500 because we had to correct that amount from the 250 he pays. Yes. So it's 500 now. Thank you, Your Honor. So yes. So Mr. Johnson, are you in agreement or disagreement with paying current child support of 500 a month?
Is that with the back child support?
No, that's just like current.
I'm in disagreement with that.
Okay, and what are your reasons for disagreeing with that amount?
Well,
I have a
because
question, and maybe I need to get Ms. Young-Fleeton back, and I'm sorry to interrupt.
Okay.
So he said it was 125, or was it 125 or 150?
He
Oh,
said 125 every 2 weeks.
2 weeks. Okay.
Yes.
Okay. So wouldn't that be 270 off? Is that what she deducted? I thought she said a different number.
Let me see.
It's not just multiplying by 2.
Right. So let me look. So if it's every 2 weeks, it's 125 times 26 divided by 12 is 270. It is 270. Let me go back to my screen. I'm so sorry. So through 3212, 270. That would be 496.
Okay.
That is the correct. Okay. May I use that amount going forward, Your Honor?
You may, and he can explain why he disagrees.
Okay.
I just want to make sure it's calculated correctly.
Yes.
As close as possible.
I agree. Thank you. So, Mr. Johnson, with the corrected amount, the child support would be $496 a month. Do you agree or disagree with that amount?
I disagree.
And what are your reasons for disagreeing with that amount?
Because I'm just not figuring out that this is my child.
Okay, well, we're not discussing back child support yet. So if there was no retroactive or back child support, it would be $496 a month. Do you agree or disagree with $496 a month being the basic child support amount?
I disagree because every time that she's asked me for something, I've gave it to her.
So do you understand this is going forward, this number?
Yes, ma'am.
Okay, so going forward, if mom calls you up and says, I need $300 for music lessons, you know you don't have to do that. Is that correct?
Yes, ma'am. Now that I do.
Okay,
but
you're
in the essence of doing what's best for my child, they'll put me, in a bind.
okay. So let me switch gears to the back child support. You heard the testimony that based on the first calculation was based on the years that you said retroactive, like you wanted it to only begin in 2023. Is that correct?
It's beginning there. That's when I went to go get a paternity test for myself, so I can know before I start spending any more money on this child, and before I gave Natalie the okay to, hey, anytime you call me, I will be there.
We lost her. So keep that in your head, sir. I don't want you to lose it, but she's not here hearing it.
Okay.
She's in a car. And correct me if I'm wrong, maybe she moved to a breakout room. I don't know. I just don't see her anymore. There's a lot of people on the screen. I guess, Mr. Hernandez, do you remember the question, and then he can re-answer it so she can hear the full answer?
Yes.
The answer. Okay.
So, Mr. Johnson, why are you asking that retroactive child support not begin to be calculated until May of 23 till the present?
Because every time I was asked to do something for my child, I've done it.
I think you were given a different answer last time, sir. I do want to hear both, but
I think you said that
paternity tests?
You said you had to do,
Yeah, I gotta.
let me rephrase the question, Mr. Johnson. When did Miss Parker tell you you might be the father of Ari?
She never told me that.
So,
When she was showing up at my house, that's what she was trying to tell me that. But from my past, like I said, there was some violence there, and then I avoided her because I didn't want any violence or anything like that. So after the first 4 or 5 times, that's when we sat down and she told me that Ari was mine. And about a year to 8 months.
Before you continue, what
Okay.
time frame was that 4 or 5 times?
objection non-responsive, right. What is the year, month and year, if you recall, that you first suspected Ari might be your child?
I can't recall, to be honest with you.
Okay.
It's been 4 years. I can't recall, to be honest with
Okay, so let me rephrase it. Ari was born October 19, 2020. When she was born, did you have any idea of her existence and that you might be the father?
you. No, ma'am, I was told I was not the father.
Okay, and who told you you were not the father?
Natalie Parker.
All right. A year goes by. When the child turns 1, did you have any idea that she might be your daughter?
No, ma'am. I saw Natalie in the club one time, and she made a scene in the club, and I left the club after that.
Okay, so then another year goes by. Ari is now 2 years old. Did you have any idea to suspect you might be Ari's father?
No, ma'am.
All right. Another year goes by. It's now October of 23. Did you have any idea to suspect Ari might be your child?
I mean, after she was showing up to my house several times, we sat down and we had a conversation, and that's when we made some agreements.
So was that in the year of 2023?
Late in the year 2023, yes, ma'am.
Okay, and you said you did a DNA test between you and Ari. When did you do that DNA test?
Probably I did it on my birthday, December of 2023.
Okay, and it came back as you're the father, is that correct?
Yes, ma'am.
All right, so is it your testimony that you do not want retroactive child support to be granted back 4 years to the date of her birth because you didn't know you were the father?
Yes, ma'am.
All right. And based on the testimony of the amounts given, does those numbers sound or seem correct if the judge were to go by those dates? If you don't know, you don't have to reply.
I don't know, because those were a lot of numbers, and I don't know what's being, calculated in anything, to be honest with you. But to say this, I mean, once I found out it was my child, I gave her access to me, access to my support system, access to anything that she needed for the well-being of my child.
Understood. Thank you. Pass this
Actually,
witness.
what does that mean, access to him and his support system? It's not understood.
Access to me, access to my mother if she needed anything.
So what all did y'all do? What does that mean? There's numerous people I know, and they do different things for my children. Like, what are we talking about?
So if she needed a babysitter and I wasn't available, she could have called my mother. You know what I mean?
She could have, but I'm trying to figure out what you and your support system did for the child.
She has before.
Okay.
So it's when she wants to.
Okay.
Like I said, she has open access to like me and my support system. So if she wanted to take that as an option, and she has used it before, we've had no problem.
So how often would you say your support, your mom or your family or you have taken care of Ari or babysat her? Do you know?
No, ma'am.
Would you say more than 5, more than 15? Do you have an idea?
About 5 or more, yes, ma'am.
Okay. And is your mom is your mom comfortable with Miss Parker calling up saying, "Can you help with babysitting?"
Yes, ma'am. She has my mother's number, just like she has my number.
All right. Does that help, Your Honor?
It's up to you what testimony you want to present. I just wanted to let you know, I did not fully know what.
Okay, no, it's okay.
His support system meant. I just didn't.
It's all
Because
right.
it can mean a lot of different things to a lot of different people, and I don't know
Right.
what's relevant and what's not to this issue. So
Understood. Yes, no worries.
right, it's up to all y'all what testimony you want to present. I'm not trying to
No,
direct
no,
that
no.
or limit it or require specific
No,
things.
I just want a good record as well. Pass this witness, Your Honor.
Okay, you may call your next witness.
Okay, Ms. Parker, are you in agreement or disagreement with child support being set at $496 a month per month?
That's fine.
And when it comes to the retroactive child support, are you asking that the retroactive child support be set back 4 years according to the testimony given by Ms. Young Fleeton?
Yes, ma'am. That's correct.
And what are your reasons for wanting the child support to be set that far back?
So, we knew that there was a paternity issue. So I let both parties know. And so when the child first arrived, the other party went and got a DNA test within the first week or so of her being born. And so that was fine because I wanted to know who it was. After that, I started reaching out to Mr. Johnson. That was within the first year. I would say maybe the first 2 months. So, like she said, January 2021, he knew that actually when I got pregnant, we were living together. And so we had gotten into an argument. He embarrassed me and I asked him to leave. And then he wouldn't leave. So I just said, "You're not the dad." So that's where he gets that from. After the child was born, I never told him he wasn't the father. So I started reaching out to him in 2021. I seen him in public and I went to his mom's house. Yes, I did. I did all of that, but I was not violent or in any way. I was telling them like I needed help. And I asked for help. And for those first 2.5, 3 years, they avoided me and they did not help me at all. At all. He said that we sat on and made an agreement. I don't know what agreement he's talking about. We didn't agree to nothing. And even if we did agree to anything, it was just that, okay, that's my baby. That's it. That's it. I didn't even know he got in a DNA test in 2023. I thought he had just accepted his child from back when 2021. I had no clue that he got a DNA test, but I'm glad that he knows that that's his baby since he still was on the ropes about it. I'm so glad about that. Also, he currently does not pay any.
Go ahead.
No, I think she's off your question. At this point, I think you need to ask a new question, Ms. Hernandez.
No, it just broke up, so I thought.
Well, I think at this point, I think it's a narrative, and I don't think she's
Yes.
answering the question anymore. So if you can ask another question,
So,
that would be helpful.
Ms. Parker, for your daughter, did someone sign an acknowledgement of paternity for her?
Yes, because the other person was there at the hospital with me. They were helping until they found out in the first week of her being born that she was not theirs. So then that's when I started reaching out to Mr. Rayson Alexander Johnson.
Okay, so next question was that acknowledgement of paternity rescinded?
Yes.
Okay, and when was it rescinded, if you recall?
Probably about, I want to say it was either December 2020 or January 2021.
Okay, so shortly after Ari was born, correct?
That's correct.
And when you say you started reaching out in 2021,
No. I'm sorry. Let me just, I have a question. It looks to me like Ari was born October 2020, and she just, okay, January. Well, okay, so you meant December 2020 or January 2021. Okay, you may proceed. Sorry.
Okay, thank you. So, Ms. Parker, when you said you started reaching out in 2021 to Mr. Johnson, were you able to get a hold of him?
Yes, I got a hold of him several times. I emailed him. I called his mom. His mom actually told me to go ahead and file child support because she couldn't get him to do what he needed to do. She said he was a grown man.
Okay. And so nothing further past this witness.
Okay. Do you have any other witnesses?
No, Your Honor. Thank you.
Okay. The state doesn't represent either of you, so I'm going to give you both a chance if there's anything additional that you need to tell me. Mr. Johnson, is there anything additional you think I need to hear about either the current child support amount or the back child support?
No, ma'am. I just want to explain my situation and what was going on from time to time. that led up to everything till now.
Okay, I don't know that we have time for all of that, but you can summarize and maybe give me the short version. Because that
Like
4 years worth of information could take hours. So I just want to let you know, we do have other cases set today.
okay,
But
just
I
want
don't want to cut you. I still want to hear what you have to say. I just want to make sure you know it has to be like a summary.
I just wanted to be noted that it was a violent relationship, and the reason why I was avoiding her was because of the violence in the past, and I didn't want to be caught up, or I didn't want to be a part of that, and I didn't want anything to be further with violence or anything like that. You get what I'm saying? So, far as contacting me and she saying I was avoiding her, it's because she didn't reach out correctly. She was just showing up unabruptly. She was just, showing up and just making a scene when she seen me in public, and I was avoiding that just to be fair to myself. So, like I said, she told me that Ari wasn't mine, and at the time she owed me some money, and I requested. I said, "Hey, if you think the baby is mine, I requested a abortion. We had 2 abortions before, so she know I didn't want a child. So I requested an abortion, and she said she agreed to that. She verbally agreed to that, and I have the text message to prove that. So moving forward from that, when she was showing up and making a scene and everything, we sat down and we had a conversation, so it wouldn't be any confusion. It wouldn't be any more outrageous scenes or anything like that. So in my part, I was agreeing to, like she said she needed help, and I was like, okay, well, if you need help, like I said before, just let me know, and you have open to my support and to me. And I don't know, what testimony she got from my mother, but I don't believe that my mother has said that. But I want to state, when she was coming around after the 4th or 5th time, I told her, hey, this is what we can do. This is what we can work out. We all had a verbal agreement. And just like I told Miss Fleeton today, if this was court, I would subpoena other
This court,
witnesses.
sir.
Yeah, I understand that, but I didn't know. I didn't know I was supposed to subpoena the witnesses that I have, that was going along with my testimony and my story.
Did they not let you know in the back you could like text or call people while you were waiting for this hearing, which started at like 12:40? That they could zoom in? It didn't dawn on you that they could zoom in?
No, ma'am.
Is there anyone you want to zoom in today to testify on your behalf, sir?
Her mother, my mother.
Okay, why don't you reach out to them right now and see if they can arrive?
Okay. Okay. Hello?
Sir, one moment. I believe the AAG is not here right now, so bear with us a few minutes while everyone gets back. Okay, is everyone ready to proceed?
Yes, Your Honor. I would like to object to the testimony about anything may or may not have been said prior to the hearing. Nothing stated during negotiation conferences or settlement conferences are not admissible in court. So I would just offer that we're almost.
Which answer are you referring to now? Because I'm not sure what he's calling the witnesses to testify. Are you objecting to what his witnesses might or might not say, or are you objecting to something
That he said that Miss Fleeton said this and that he didn't know about this. So anything he said about what allegedly might have been said in the settlement conferences prior to coming for the hearing should not be admissible in court.
Okay, I'll sustain that objection. Sir, do you have any witnesses you'd like to call?
I only got in contact with my mother, and I couldn't get in contact with her mother.
Okay, is your mother testifying?
Yes, ma'am. She can tell you that,
No. Don't tell me what she's going to tell me. That's hearsay.
Okay.
Is she zooming in to testify?
You want her to be on Zoom? I don't
She
know
needs
how
to
to
be
link.
on Zoom to testify, sir. Everyone needs, this is just like court. When you have a witness, they need to be in court.
Okay, I don't know how to link a Zoom to anybody, this is my first time using Zoom, so I don't know. Like I said, when I was at the Attorney General's
Okay, sir,
office this
sir,
morning.
Objection.
you talking to me is not making this going to go faster. You need to figure
Okay.
out how to get your witness here on Zoom. And so you can either forward them whatever information the AG sent you. It's the same Zoom information, or you need to talk to them on the phone and talk them through it. These are your witnesses.
Okay, I can put her on video right now.
She needs to be on Zoom, sir.
Okay.
I don't know what it means to be on video.
Okay. Mother. Ma'am, how do I send her the link?
I can give you the code. The code, 1 second. Let me pull up the code. You would tell her to go to Zoom. 1 second. The it is 853.
Okay, my mom is downloading Zoom right now.
Thank you.
And I think Ms. Parker's mother is as well. So we'll see what witnesses show and we'll just take them as they show. And please remember the issues are only child support and retroactive child support. Everything else is agreed to. If you start getting testimony about other issues, the agreement, you either have an agreement or you don't.
Did you say Lisa Johnson?
Lisa Rayson, Rayson.
Thank you.
And who are you?
I'm Rayson's mother.
Rayson Johnson's mother?
Yes.
Okay.
Thank you.
Okay, ma'am, if you can raise your right hand to be sworn in.
Okay.
If you can move your camera back so I can see it's up. Okay. Do you solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. And Mr. Johnson, this is your witness, so I'm going to let you ask her questions. Please remember they must be questions. You can't testify for her. And make sure they're only one question at a time. As you've probably just experienced, it's not easy to answer multiple questions at once. So you may begin, sir.
So these questions are for retro back child support when I didn't know that Ari was mine, and Natalie told me that the baby wasn't mine, and when she was showing up to the house being abrupt.
Objection to form.
So sustained, sir. Again, it has to be in the form of a question. You just have to ask her questions that she can answer.
So did Natalie show up to the house causing a scene and stuff like that?
Objection to relevance.
What time frame are you talking? So when did this possible? What are you need to be a little more detailed.
When she was reaching out and she was trying to tell me that the child was mine after she told me that the child wasn't mine.
So what's your question?
My question is, when she was showing up to the house, did she show up to the house and several times
she showed up to the house several times.
Unannounced and stuff like that?
Yes.
So, Your Honor, from the past,
objection to time frame.
Yeah, sir. Ms. Rayson, do you know about when this was?
The 3 to 4 times that I explained in the beginning.
Objection to
Ms.
testifying.
Rayson doesn't know what that is. Yeah, you have to either ask her for time frame. You have to either have a time frame or ask her a time frame. You have to ask questions, sir, that are understandable to everyone.
I don't have any time frames because it was 2 years ago. I wasn't calculating any dates specific to.
Well, I know She was coming when the baby was like 3 months old. She was still carrying the baby.
So Ms. Rayson, you just said she was coming over to Mr. Johnson's house when the baby was 3 months old and even when she was pregnant?
Not when she was pregnant.
Okay.
The baby had to be small, like 3 or 4 months old.
Okay.
Because she would have it in her hand, meaning that.
Got it. Okay.
So, yes.
Thank you, Miss Lisa.
Uh-huh.
Ms. Parker, please wait till it's your turn.
Mr.
Objection.
Johnson, do you have other questions? Sustained. Yes, right now, Mr. Johnson is asking Ms. Rayson questions. So only he should be asking questions and then Ms. Rayson should be answering. Mr. Johnson, do you have any additional questions for Ms. Rayson?
Raisa?
Not at this time now.
Okay, thank you. And Ms. Parker, do you have any questions? Just like I asked Mr. Johnson, questions for Ms. Rayson to answer.
No further questions. Thank you.
Okay, and Ms. Hernandez, do you have any questions for Ms. Rayson?
No, Your Honor. Thank you.
Okay. Ms. Rayson, thank you so much for coming in today. We are going to use you since no one has any more questions for you, but we appreciate you zooming in.
All right, thank you.
Thank you. You can log
May
out.
she be okay, may she be excused?
You can log out, Ms. Rayson.
Okay.
There's a Miss McGraw in the breakout room, but in the waiting room, but I feel like, was she on another case? Or is she Miss Parker's?
Is Miss McGraw with you, Miss Parker?
Name
No.
looks familiar to me. I think she's in another case.
Okay, thank you.
I'm not sure, and I have no easy way to check.
She should be in room 32, Judge.
Okay. Ms. Parker, is your mother coming in? Are we waiting for any other witnesses?
I was waiting for her, but I don't think we need her anymore.
Okay. Okay. So, Mr. Johnson, is there anything additional you'd like to say before I rule?
No, ma'am, I don't have any choice in this matter.
Okay. And Ms. Parker, do you have anything additional you'd like to say?
No, ma'am.
I'm going to, and oh, Mr. Johnson, before just want to make sure you have no other testimony about the current child support.
I mean, I believe I don't have any choice, ma'am.
Well, I base current child support on income. So are you disputing that, or do you have any reason that it's not appropriate?
I mean, like I say, I don't have any choice, ma'am. Like I say, I've been trying to take care of my child the best way possible that I've been allowed to. So I wouldn't come to this point to be on child support. So I'm just going with the flow, ma'am.
Okay. Okay, I'm going to render judgment. I'm approving the agreements of the parties. I'm establishing the parent-child relationship between Mr. Johnson and the child, Ari. I am establishing a joint managing conservatorship between the parties, with Ms. Parker having the right to determine the primary residence of Ari within Galveston and any county that touches Galveston County. I am ordering that visitation will be for a standard possession order. And I'm ordering that Mr. Johnson provide the medical insurance and dental insurance at his expense through his employment, I believe. And I'm ordering guideline child support for one child. And sir, just to confirm, you don't have any other children?
I do have other children.
Are they under 18?
One is 18 now and one is 21.
Okay. Is the 18-year-old still in high school?
Yes, ma'am.
Do you pay child support for that 18-year-old?
Yes, ma'am.
Are you aware of this, Ms. Hernandez?
No, Your Honor. Is what is hold on. So the child is that the child Rayson or Anthony?
Anthony,
And he's still in high school and you have a current support for him?
yes, ma'am.
When is he
Okay.
graduating?
I couldn't hear you. I'm sorry.
When is his graduation date?
I can't. I don't know, to be honest with you.
Do you know what
The
grade he's in?
he's in the 12th grade.
Do you know what school district he's in?
He's in Lamarck School District. They graduation dates change from different time to time.
But it's this year. It's like in a month.
Yes, ma'am.
So the child is graduating is this year, like May or right now?
Sometime this year, yes, ma'am.
And I'm looking right.
I'm sorry, Ms. Hernandez, did you figure it out already?
Yeah, I found based on the name that cause number is 06 FD 1955. One child was born, Rayson was born in 04, the other child in 07. And it looks like child support ended, or it's ending March 31st, 25. It just ended. Or it's, yeah, I don't have any.
So the March 1st payment or child support accrued, and there's no other further accruals.
Correct.
I've been paying past March, so I didn't know that.
Well, because it's graduation date.
Okay.
The child's birthday is March 5th, 2007.
You probably didn't get a graduation letter to extend it. So.
Right. So he's graduating in May, but his birthday was March. So it's when he graduates. So
that means I'm still paying on him.
Right. So do you know if he's graduating? What I can do, Your Honor, in this case is start the child support June 1st instead of May 1st so that we don't have to, recalculate it. We can use the 20%, but start at June 1st because this one's ending May 31st, if that assists the court in any way.
Well, we're already on May 5th. What date are you offering? Are you saying July?
No, June 1st, because the child is graduating May 31st.
Ms. Parker, do you know the graduation date for Lamarck?
I believe it's May 16th or 17th for Lamarck High School.
Your Honor, if July 1st is more amenable, we're fine with that.
I was hoping someone could Google.
Let me see.
School. Because I'm not supposed to research, but it's
okay. I know what you're saying. Lamarck graduation date. It says May 24th, 2025 at 2 p.m. Moody Gardens Convention Center.
Okay.
Yes.
So as I said, it's a joint managing custodial standard possession order. Mr. Johnson is ordered to provide insurance and dental insurance. I'm ordering child support per guidelines at $496 per month beginning June 1st of 2025. I'm ordering a retroactive child support judgment against Mr. Johnson in the amount of $14,500 as of today, May 5th of 2025. And I'm ordering that he pay that back at a rate of $80 per month beginning June 1st of 2025. I am denying the non-disclosure request, and I'm ordering court costs to be paid by Mr. Johnson by May 5th of 2026.
Thank you.
Yeah, so the state's going to draft the order based on my ruling today, and they'll be sending it to both of you through DocuSign to review and sign off on. And then once you do that, you'll be free to go. But thank you both for coming in today, and good luck with everything going forward.
Thank
Your
you.
Honor, Your Honor, I'm gonna receive that information through an email or text message or.
Yes, sir. If you go back into your rooms, we're going to draft the orders and get them to you to sign and answer any questions you may have.
Okay. So could I come up to the Attorney General's office and sign them, or do they have to be?
No, we'll
done
do
by-
it on DocuSign. We're going to send it to you to your email on DocuSign. You don't have to come to the office or go anywhere. Just hang tight in your room. We're going to draft them, send them to you so you don't have to leave where you're at.
Okay.
Okay. Thank you.
Do you each solemnly swear
And
that any
my-
testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, thank you both. And you may lower your hands. And counsel for the Attorney General's office, please state your name.
Valerie Laskowski for the state.
Okay, and before we begin and get into anything really, I know that there was a de novo pending. It looks like it was set on April 28th, but I don't know what happened that day. Do you know, Ms. Laskowski?
Judge,
Mhm.
it was effectively denied.
Okay,
She didn't deny, she just didn't agree with it. It's a difference.
okay. So we're ready to proceed today with final trial?
Yes. Yes.
Yes.
Okay. Okay, a few housekeeping items before we begin. You might remember them, you might not. Basically, I am an associate judge, so you do have a right to a de novo hearing before the referring court regarding decisions I make. Also, nobody should be recording this hearing. There should be no video, audio recording, taping, broadcasting, photographing of any kind, this or any other court proceeding, and that includes people here on Zoom today and people who may watch on YouTube. And then also, even though you're in your homes or somewhere with a bridge, we treat this just like court, and you are in the courtroom. And so please remember to not leave, just like you would in the courtroom. You didn't run out on Judge Fisher's de novo. You shouldn't run out on this. If you do, I don't know if you're frozen or not, and so it makes it real hard to know if you're able to hear, which is critical for you to participate. Also, we generally take testimony in court where one of you is asked questions at a time. And so if you're not the person being asked questions, Mr. Harden, are you still there?
Yes.
Okay, great. Just wanted to be sure you were still with us. If you're not the person being asked questions, unless you have a legal objection, please don't interrupt the person answering or answer for them. And you'll both be given a chance to be asked questions, and you both will be given a chance to speak as well at the end, since you're both representing yourselves. And then lastly, just know I'm not with the Attorney General's office, and so anything that you've said to them or given to them, they are not allowed to tell me about it before the hearings. The only information I get is when we're having these hearings and everyone hears it at the same time. It's an ethical violation for them to come share with me what they said in the back, and they don't. And so you're going to be asked questions that you've probably discussed, and just be aware of that. It's might feel repetitive, but it's important you answer the questions. Mr. Harden, are you still with us? Now I'm hearing background noise and we've lost you. Okay, just want to be sure you're here. And Ms. Laskowski, you can begin. But are there any agreements?
Only between the state and Ms. Lewis, Judge.
Okay, so he does not agree, so it's a contested matter.
Yes, Judge.
Okay, you may call witnesses. I do want to just say I'm hearing some background noise. Hopefully it has stopped. But if you're in a room where someone else is watching TV or around and talking, please make sure you go to a place where it will be quiet so we can all hear. It's hard enough to hear on Zoom, but any little thing that interrupts makes it harder. So please make sure you're in a quiet space. And you may begin.
Judge, the state and Ms. Lewis are asking for the court to finalize the temporary order and take a child support judgment against Mr. Harden in the amount of $25,038.05 as of
What?
$25,038.05 as of April 30th, 2025, and order Mr. Harden to pay that judgment off at the rate of $150 monthly, beginning June 1st, 2025. The state and Ms. Lewis are also asking for the court to take a medical support judgment against Mr. Harden in the amount of $7,247.30 as of April 30th, 2025. In order Mr. Harden to pay that judgment off at the rate of $65 monthly, beginning June 1st, 2025. This state and Ms. Lewis are asking for the court to take a zero dental support judgment against Mr. Harden, and for the court to order Ms. Lewis to apply for a government health plan for the children. The state and Ms. Lewis are asking for the court to order Mr. Harden's current child support and medical support obligations be based on his gross monthly resources, the court's previous finding of Ms. Harden's, Mr. Harden's gross monthly resources.
Okay.
Of $5,131 monthly, with 2 children before the court and no others that Mr. Harden has a duty to support. The state and Ms. Lewis would ask the court to order Mr. Harden to pay $150 monthly cash medical beginning June 1st, 2025, and current child support in the amount of $1,035 monthly beginning June 1st, 2025. The state would ask the court to assess court costs against Mr. Harden and order that Mr. Harden pay those as billed by the Galveston County District Clerk on or before May 5th, 2026. And lastly, the state asks the court to make a ruling on the issue of non-disclosure of the party's contact information.
Before you begin, Mr. Harden, would you like to try to make an opening similar to what Ms. Laskowski just did for yourself? Not getting into any details of the case or testimony to back it up, but just a summary like she just did?
Yes.
Okay.
I'm just agreeing with the medical part.
Okay. You're disagreeing or you're agreeing? I'm sorry, I couldn't hear that.
I'm agreeing with the medical part.
So you are agreeing to medical. Okay.
Yes, ma'am.
Okay, thank you. And you're disagreeing to the judgment?
Mm-hmm.
Okay, and the current child support? Okay. Okay, you may begin, Ms. Laskowski.
The state would first call Ms. Lewis. Ms. Lewis, do you have a court order for Mr. Harden to pay you current child support and medical support?
Yes.
Is Mr. Harden current in those obligations?
No.
Does he owe you money?
Yes.
Have you had an opportunity to review an updated pay record in this case?
Wasn't that January 13th? I think so. Yes.
It's the one I also sent one from
Today.
Right.
Yes.
Okay. And at this time, I'm going to share my screen. At this time, the state would offer what's been, actually, I'm not going to offer it yet. Okay. Ms. Lewis, I'm sharing on my screen a copy of the an updated copy of the pay record in this case. Does this pay record correctly reflect Mr. Harden's support obligations?
You're not sharing anything?
Yeah.
Oh. Ms. Lewis, does this correctly reflect Mr. Harden's support obligations?
I would not know. I rarely receive income from him, so I don't keep up with it. But I guess I will say yes.
Ms. Lewis, has Mr. Harden ever made any support payments directly to you?
No,
Are there any payments for support that Mr. Harden made that are not reflected on this pay record here?
no.
Wow, that's crazy.
At this time, the state would offer what's been marked for identification purposes as State's Exhibit 1.
Ms. Lewis, do you have any objection to me admitting State's Exhibit 1?
Nope.
Okay, and Mr. Harden, do you have any objection to me admitting State's Exhibit 1?
Yes, I have objections.
What is your legal objection, sir?
My legal objection is over the past years I've been on child support, I've sent her plenty of direct payments. I know y'all said we're not supposed to do that, but I have sent her plenty of money. Plenty, plenty, plenty. And she's just sitting there lying, saying that she hasn't received any when she has.
That's a different, that's not a, well, I'm going to overrule your objection with regard to this exhibit. Please know that it doesn't mean I don't want to hear about that later. It's a separate issue, not the exhibit.
Oh, okay. I
That's an
agree.
issue
I
that-
agree. I agree.
yeah.
I agree with
That
the
means you
exhibit.
disagree with the child support amount, and I'm not at all telling you not to tell me that later.
Okay.
But I am going to
right.
admit this exhibit as what the state shows went through their registry and what is due. Do you
Yes.
just agree that that's what it shows?
I agree. I agree with the exhibit.
Okay.
Yes.
Thank you. So I'm going to admit State's Exhibit 1. It's admitted.
Ms. Lewis, is there any family violence between you and Mr. Harden?
Yes, I have it on recording.
Does Mr. Harden
The
know?
last incident we had, we've had no, he doesn't know what my current address is.
Do you have safety
Though
concerns?
he possibly does.
Ma'am, wait till she asks the question because it almost sounds like
Mm-hmm.
I'm just, maybe you're hearing questions I'm not hearing, but let Ms. Laskowski ask you questions before you answer them.
Ms. Lewis, do you have safety concerns being required to tell Mr. Harden your current address and contact information?
No, I don't. I just don't want him to know it because he is a verbal abuser. That's it. No physical concerns, though.
Can you give the court an example of this verbal abuse?
I have a video.
Okay. When was the last time any?
We lost her. Ma'am?
I'm still here. I'm just trying to pull the video up.
Why don't we give her a moment then, because we don't know if she's frozen or not when she's in that state.
It says only the host can share the meeting, so I cannot share my screen.
Have you sent the video to the Attorney General's office?
Yeah, well, apparently the file was too large, but I did go ahead and there is a incident report on file for it. This happened on September 14th at 11:53 a.m. And I made the I believe that following Monday is when I made the incident report.
September of what year, ma'am?
2024.
And can you tell the court what happened?
Yes, it was my children's homecoming for Little League. And he was trying to take our children out of the thing before they were actually supposed to be dismissed. And so I had let him know, hey, just let her wait until she's dismissed and you can take her. He started shoving and pulling on my daughter. I have it all on recording. And this happened in front of everybody. I have multiple witnesses in my family as well. And I have it on record. I started recording once he started getting real verbal with me. He called me all my name, B words, all types of stuff. This is all doing with child support.
Okay, so do you think that rises to the level that he shouldn't know your address or phone number?
Yeah, I prefer to do everything through text app. He is currently blocked and I'm not unblocking him. I'd rather every communication that we may have further going go through a text app.
Are you asking for the,
All I'm addressing in this lawsuit is modification and confirmation of arrears. Does anyone know if the visitation pickup and drop off is their houses?
He doesn't get them.
I don't know her address. So how am I able to get my kids if I don't know her address?
Her address was actually in the last court order, but okay.
No, she just moved. She moves every year, man. She has moved residents like five times in the past 5 years, or at least 4. She's not stable at all. So
Sir, wait till it's your turn to testify.
okay, thank you.
Can someone give her co-hosting ability so she can share her screen, please?
I don't do this in front of my kids. He want to show. It's okay. I just have to make sure. That's fine. He ain't doing nothing to me but talking. You gonna be talking at 1,400 out of his pocket too. Just text me. Text me. You the one that don't want to sign it.
When I call housing.
Hey, do whatever you gotta do. Go
people in the house ain't supposed
do whatever you gotta do.
I already called them.
Okay.
You'll be seeing somebody else up real soon.
Text me when it's time for that. Okay. Okay.
Yeah.
You about to be Flintstoning? I'm about to take your car. I'm about to take your car. Flintstoning. You're mad. Yes, sir. Oh, I got you. You paying for it. I got you. You paying for it. Come on. We waiting on the lawman, baby. We waiting on the lawman.
Okay. Okay, Mrs. Kelsey,
He's
you may
threatening to
continue
take
with
my
your-
housing. He's threatening to take me off housing.
Ma'am, are you
and
like
things
right
of
now
that
as during this
sort.
hearing, you're getting text messages saying that? Is that what you're saying?
Never once texted her any of that.
Okay, ma'am, I'm horribly confused with what you're saying because this is testimony and you're just throwing out information to us. So I'm a little lost at where we are. Ms. Litkowski, are you frozen?
no,
Okay. You may continue with testimony.
all right. Pass the witness, Your Honor.
Okay, Mr. Harden, do you have any questions for Ms. Lewis?
Questions for her? Oh yeah, I just want to know my address. I mean, I want to know where she.
No, this is not the time to just talk. This is the time to ask questions of Ms. Lewis if you have any. Do you have any questions for Ms. Lewis?
Yes. Why is she doing this? That's what I want to know. Why?
Okay, you have to direct the questions to her, just like Ms. Liskowski did. Follow the same structure Ms. Liskowski followed if you have a question.
Okay, Miss Ashley Lewis, why don't you want to give me the address to where you live?
Like you already know before, there has been numerous times you have disrespected me. You literally every time have threatened to uproot my children from their home because you are sad.
Have I ever physically abused you or put my
Doesn't
hands
matter.
on you?
I have multiple videos. That was just
Have I ever physically put my hands on you?
verbal abuse is physical abuse. It's all the same, sir.
I passed
And
the
I'm just
witness.
not tolerating it no more. So
I passed the witness, ma'am.
thank you.
Ms. Liskowski, you may call your next witness.
The state will call Mr. Harden. Mr. Harden, you previously indicated that you do not agree with the judgment amounts reflected on the pay records. Why is that?
Yes, I would ask that the state do not object when I read this out, please. 1 second. Okay, first, I acknowledge that I am responsible for contributing to my children's Medicaid coverage, and I fully understand and accept this obligation.
Sir,
However,
I'm going to stop you. If you can answer the question that was asked, it would be helpful. I've
oh,
already read I've read your
okay.
de novo request, and I think
Oh,
that's what
okay,
you're
okay,
reading.
okay,
It sounds
okay.
identical.
What was the
But
question
this is
again?
not the de novo hearing, and Ms.
Okay,
Laskowski asked you a question. So Ms.
okay, I'm
Laskowski, you can
sorry.
re-ask the
Can you
question so
repeat
he
the
can
question
answer it.
again?
All right. Sir, why do you disagree with the support with the arrearage amounts reflected on the pay record that was admitted into evidence earlier in this hearing?
Because for the past 3 years, Ashley has basically came to me and said, "Hey, Link, I'm going to take off your arrears and I'm going to delete them." Basically, we both went up to the Attorney General ourselves and tried to process that, and they told us we had to do it online. I have text messages from her saying that she did submit, and also another text message of saying how, "Oh, you're doing a good job, so I'm gonna take 10,000 off your arrears." I have that information. So it's like she's playing, she's saying she's gonna take the arrears off, but she's not doing it. And we've been doing this for 5 years. So that's why I don't agree with them.
Have you made any direct payments for support directly to Ms. Lewis?
Yes, ma'am. Several.
All right.
Several.
Since the time of since the establishment order.
Since the establishment order, no, I haven't made any payments. But like years, when I wouldn't say years, but like Apple Pays and like Cash Apps and all that, I've sent plenty of money to her. And she also I also contacted the courts, and they supposedly had sent her alpha data to where she can fill out the information, so I can get credit for those direct payments that I made. But she never submitted it, and she never gave me credit for it.
What time frame are we talking? I'm lost. When you say establishment order, Mrs. Kelsey, what order are you referring to?
So the establishment order was in 2014.
Okay.
There was, or the first establishment order was 2014. A second establishment and confirmation order was in 2018. And then we're on the state's current confirmation and modification. So Mr. Lewis, or Mr. Harden, since the order from April of 2018, have you made any direct payments to Ms. Lewis?
Yes, I have made several.
Okay, and do you have any dollar estimate on those, what those
Oh
payments?
yes, hold on 1 second. I can pull up my Cash App right now. And I was just screenshotting and then I was sending it in the chat.
And feel free to keep doing that, sir.
Oh, yep. Yeah, right here. Okay. This is from okay, as of right here, it says 8,000 has been sent total. And hold on, I'm screenshotting it right now. And these are payments all the way since 2018. So I'm about to send all of it to you. I guess they don't have all of the payments I sent, but yeah. In total is 8,000 I've sent to her that I haven't got credit for, and she refused to sign the alpha data, and I'm sending that to you right now. As you can see, that's her. Her name is Winter Rose on there, but it's 82 transactions I've sent, and it says 8,000 on there.
Where does it say 8,000? I don't think it all came through, sir.
No, it did. If you look at the picture, it says 82 total transactions, it says 50 received, and it says 8,000 sent.
That's a different document. Okay.
It's in the chat. It's the second photo I sent. And that one was just, that first one is just a depiction of payments I've sent to her.
What is total receivement versus total sent?
That's 8,000 that I sent her, and I guess it's just 50 she probably sent back to me or anything. I don't know. That's what it is. But I've been trying to get credit for that since 2019. I never got credit for it. And I have Apple Pay payments also to Miss Lewis. So that's why I didn't understand why would she lie and say that she didn't receive. That doesn't make
Kelsey, are you ready to begin testimony again?
Yes, Judge.
I think you're still right? We're not up to where he just speaks.
Right. Mr. Harton, you mentioned that you have you made direct payments through Apple Pay. Do you have a dollar amount on any direct payments you made with that service?
Hold on. Let me look 1 second. Sending that over to you now, but that's nowhere near close what I sent on Cash App, but it's just to show you that I have sent her money. Majority of the payments were sent through Cash App. It was just little stuff here and there, like she would ask, "Oh, can you send some money so they can get something to eat?" Stuff like that, and I'll do it. But that's about it. But this the second one.
Mr. Harden,
Huh?
where are you employed right now?
I do private duty home care. I work for Robert Lau. I've been working for him since 2017, November of 2017.
And were you working for Mr. Lyle at the time of the temporary order that we're trying to finalize back in September of 2024?
Yes.
All right. Since September of 2024, have there been any changes in your income?
Somewhat.
Okay. How so?
With her.
Can we have him get his camera back on if we're going to do testimony?
Huh?
Your camera's off, sir?
Oh,
Now you're muted as well.
I don't know why.
I accidentally did that. I was trying to
Oh,
start.
it's okay.
All right, there you go.
I just want to make sure he knew, because sometimes people keep talking and we're not hearing.
Hello?
Yes, sir.
Okay, yes. With her asking for more money, I've had get an extra day, but it's not like for sure. So some like 50, it varies, but that's the reason why it changed a little bit, but not much really.
What did it change from and to? I'm sorry, I didn't quite follow that.
With her asking for extra, with her asking for more money, that put me in the bind for is just necessities for surviving. And so I had to ask my supervisor for an extra day.
Okay.
But that just started in November, and that's not every week.
Okay. You said it's an extra day. Is that an 8-hour day?
No, I work 12. I work 12 hours.
Okay. So one extra 12-hour shift a week, but it's
No,
not,
not.
but it's not
Yeah,
every week. Okay.
yeah.
So how often do you get that extra 12-hour shift?
What does that have to like? What does that have to do with anything? Like,
Are you salaried, sir, or are you
I get paid weekly.
okay? But is it like an hourly job or is it a
Yes, ma'am. Yes,
salary?
ma'am. Yes, ma'am.
Which one?
It's hourly.
Okay. Do you work the same hours each week?
Yes, ma'am.
Why does the wage withholding change so drastically?
What do you say?
Why does the wage withholding change so drastically?
What do you mean? Why does it change?
Ms. Wisconsin, it looks like it went from 117, 594, 237, 1545, 950, 1069, 326, 323. So it's never been the same. Anything that, and I'm assuming that's withheld.
Look. That's the thing. That's the thing. That's why I tried to talk with Ms. Lewis about her just taking me off completely so I could just make those payments. Because at first, I'm not going to lie to you, Honor. I was slacking and I wasn't like doing what I was supposed to do. But ever since I had this job, I tried to work with her and, take care of my kids. But see, with my job here, they take the money out of my check every week, but they don't pay on like how they on time. And I talked to my the guy that signs my checks, and he was like, well, the court didn't say I was obligated to pay every week, like whenever I take it out. So that put me in the bind. Like, and that been my problem for the longest.
Okay.
If if they would have been sending this money to her every week, like they take it out of my check every week, I don't think Miss Lewis would have a problem, and we wouldn't even be here right now. But I tried to work with her, and it's like she don't want to come to an agreement with me. And they're taking the money out, but they're not paying it every week. And I talked to the court, and they was like, "Oh, well, that's something you have to
Kelsey,
do." And it's like,
are you putting on testimony still? Just trying to keep the hearing moving.
Oh, okay. Mr. Harden,
yeah.
Is there any family violence between you and Ms. Lewis?
Never.
Does she know where you live now?
She know, yeah. She knows my address.
Nope, I don't.
Ma'am, it's not your turn to be speaking.
If you were to move from that address, from your current address, do you have safety concerns if you are required to tell her where you moved to?
No, ma'am.
Okay. Do you have
I don't have a problem with her. I don't know why she's making it like we're enemies. I'm trying to be an adult and co-parent and just do right by my kids. And it's like she doesn't want to just agree with me. I don't know what the problem is, but I don't have no safety issues with her knowing where I live.
Right. Is there any third party that you have safety concerns with knowing your contact information from today's court order?
Would she know? No, I don't have any of that. With
Like
her,
an ex-girlfriend, that sort of thing.
With her knowing my no, ma'am, no, ma'am.
All right, pass the witness, Judge.
The state does not represent either of you, so I'm going to give you both a chance if there's anything additional you think I need to hear about any of these issues. Ms. Lewis, is there anything additional you think I need to hear?
I don't know where he currently resides. The Frazier address is his grandmother's address where he does not reside. If it's not for me having my children's location, 1 second, I'm getting a phone call. If it's not for my children having Me having my children's location, I would never even know where they be at when they are with him, and that is very rare because he does not get his children nor see them that often. As far as the $8,000 go, those were things as such as paying for haircuts, book fare, hair, shoes, clothes, things that are necessities. So I've already spoken to a lady about that, and like she said, those are gifts. That's not direct payments.
Was
So
that a judge
again,
you
those
spoke
are
to,
not
ma'am?
direct payments.
May
I spoke to this is back in 2018 when I signed that whatever I
Was
signed.
it a judge?
I don't know who I talked to. I went inside the child support office before they cut it off for COVID, and
Okay.
whoever I spoke to advised me on that.
Okay.
And ma'am,
Yeah,
I
sir,
was
sir, 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 sir,
all
sir,
right,
sir,
all
sir.
right. I'm sorry, I'm sorry, I'm sorry, I'm
Please
sorry,
wait
I'm
till it's your
sorry.
turn. Okay. You
Yes,
may
ma'am.
continue,
Yes,
Ms.
ma'am.
Lewis.
Yes, ma'am. So again, I don't even know where he resides without my kids having their locations on. That's how I'm able, in the event of emergency, that's the only way I can find my children. Um, Again, I don't want any contact with him. I don't want him being around me whatsoever because we cannot have this. He's pleading his case, but he doesn't even get him physically or help financially. I'm over it. So I just want to cut all ties and keep it just the way it is.
Mr. Harden, is there anything you'd like to say about child? And again, uh-oh, is everyone frozen? Ms. Lewis, I'm not sure if you froze or if you were done. I thought you were done, but you might have frozen.
Um, Furthermore, I've had issues with his ex-girlfriend too. But I don't want to get into that. Yes, I am done. I can pass it to him.
Okay. So I'm just going to remind you the issues that I'm ruling on today are your current child support amount, arrears, and the non-disclosure request. Is there anything additional you'd like to say, Mr. Harden?
I have several things I would like to say. I'm speed it up, but as of that 8,000 that I sent to her, I'm gonna be honest with you. I was not paying my child support because I had to get a money order and I didn't have the direct with her, the card with. So I would send her money, and that's why we had the discussion. And she got the affidavit, and she signed it, and she said she was going to give me credit for that. She never once did that. I don't understand why I can't have her address. She makes it seem like she's just a single parent when my kids are either at her mom's house or when I can't get them, they're at my grandmother's house because I work. She doesn't have a job. She hasn't had a job in I don't know how long. She changes her housing. She gets food stamps. She get all this extra stuff, and she does nothing. But she want my money from me, and I can't even know exactly what she live with my kids. That doesn't make any sense. And I never once have a police report or anything putting my hands on her. She's putting her hands on me before in the past, and I never once touched her. And yeah, it's just I'm in the bind. That's all I got to say. I'm working. It's hard for me to get my kids when they don't stay with me, and I have to work as much hours as I do when she doesn't work at all. And that's all I got to say.
Did anybody look at his income? I know last time I think you had it through.
And like I say, I don't like I said, I don't agree with it, but if you make the ruling on it, so be it. It's fine. I'll just have to pick up extra hours, and then she's gonna have excuses why I'm not getting my kids, but I have to work 60 hours a week. Like, come on, and they don't stay with me. So that's why I wanted to ask you a couple questions. For as when it comes to income taxes, is it my right that I can carry my children?
I can't give you legal advice. You'd have to speak to a tax consultant.
Okay.
But what I am here is to hear evidence about your income. Right now, I have to rule based on evidence presented, and at this point, I've had no evidence about your income. And so that's what I'm trying to focus on,
You have
not
no
whether or
evidence of
not
my
you can claim
income.
your children on taxes. Has anyone looked at his income, or is there any testimony on his income?
He had no information on his income. No, no.
I thought y'all
Change.
looked at my W-2. My W-2 is not on file. That's how y'all came up with the amount that what I'm supposed to be paying it monthly, right?
These numbers were from September. I don't believe W-2s were sent out back then.
It hasn't changed, man. Like I told you, I've been working the same job for 7 years. Nothing changed.
Okay.
Like I said, if you want to final, go ahead with it, but just don't think that's
Right. Does anyone have anything further before I rule?
yeah.
Nothing.
My
Nothing
with the what will I get? Will you give me credit for my the 8,000 that I paid with the arrears?
Sir, I haven't made my ruling yet.
Okay. And one more thing, I'm one more thing. I know the arrears are supposed to be paid to her. Why am I being rushed to pay those arrears if that's money that I owe her, and as long as I'm working, she's going to get the money, but I don't understand why I'm being rushed to pay them. As long
Again,
as
sir, I
I'm
cannot give legal advice, or I'm not here
okay.
to. I'm here to listen to testimony on the issues before me and make a ruling. The
Yes,
AG's office can help a little in the back. They provide some more customer service in that sense. But the court is not allowed to. That's not my role.
yes, ma'am. Yes, ma'am.
Karen, could just bear with me a moment. Okay. I'm going to rule on the bid for modification of support order and motion to confirm support arrearage. And I am finding there's been a material and substantial change in circumstance since the prior order of 2018, and where it's been more than 3 years, and it's going to vary by more than $100. Sure, yes, that is true. So it was prior $265 per month. And so I am modifying the child support based on the testimony presented. And I'm ordering that Mr. Harden pay child support of $1,035 per month beginning June 1st, 2025. I'm also finding nobody has private insurance at a reasonable cost, and I'm ordering that Ms. Lewis continue with the government medical assistance program, and I'm ordering that Mr. Harden pay to her cash medical support of $150 each month. There are 2 children, so the child support amount of $1,035 will statutorily step down when one child emancipates. It will step down to $828 when there's just one child with a court. I am ordering a child support judgment against Mr. Harden. I am giving credit for direct payments made for children necessities. And so I'm ordering a child support judgment as of yesterday, May 4th, 2025, in the amount of $17,801.05. And I'm ordering that he pay that judgment back at a rate of $120 per month beginning June 1st, 2025. I'm ordering a medical support judgment against Mr. Harden in the amount of $7,397.30 as of May 4th, 2024. And I'm ordering that Mr. Harden pay that judgment back at a rate of $50 each month beginning June 1st, 2025. Both of you should know those judgments do accrue interest per the family code. The order will state this as well. Other remedies can be used to collect those judgments in addition to withholding. It's not an installment debt, and so if other remedies become available to Ms. Lewis and or the Attorney General's office, they can be pursued. I am denying the non-disclosure request for both parties, and I'm ordering court costs to be paid to Galveston County by Mr. Harden by May 5th of 2026. The state's going to draft the order based on my ruling today and send it to both of you through DocuSign to review and sign off on. And then once you do that, you'll be free to go.
Excuse me. So basically, you're just finalizing the temporary order, like nothing's changed.
I gave you credit for direct payments, sir.
So
And then the AG's office is going to send you the draft shortly, and you'll be able to see what did and did not change from the temporary order.
Now I understand that, but I'm saying when you're giving me credit, shouldn't that change the amount of arrears I have to pay monthly?
I looked at that as well, sir, when making my ruling. The state will send you the draft shortly to see everything.
Okay, thank you. I appreciate you. I've been trying to do this for years, for 6 years, trying to get credit. So I've been.
Okay. The hearing is over, and we're going to have you go back to the breakout room, okay? Thank you so much.
All right, thank you.
Thank you.
Thank you, Judge.